Hello, my name is Johnny Story. I am a senior instructor with the legal division at the Federal Law Enforcement Training Center, also known as FLETC. FLETC is located in Brunswick, Georgia. Prior to my coming to FLETC, I worked at the Office of the Solicitor for the City of Atlanta as a prosecutor. Before that, I was in private practice. As a prosecutor for the City of Atlanta from 1989 to 2007, I worked my way from being an assistant solicitor to being a senior solicitor to being a deputy solicitor. I provided legal counsel on all matters involving prosecution to the mayor's office, the office of the various members of the Atlanta City Council, and for other city agency officials. I also provided training support for the Atlanta Police Department, including the Atlanta Police Academy, and each city agency which had code enforcement agents that were empowered to issue city ordinance citations. As a solicitor, the primary duty was prosecuting all crimes arising in the city limits of Atlanta, Georgia. I conducted trials on city ordinances. With state cases, that is misdemeanors and felonies, I conducted probable cause hearings before transferring those cases to the Fulton County and DeKalb County courts. In general, as a prosecutor, I prosecuted everything from people walking their dogs without a leash to murder cases. Generally, while at the solicitor's office, I had courtroom duties every day. As you might guess, I had an opportunity to see my share of police reports. Today, I want to talk to you about report writing. Why is it important that we write a report, and what needs to be in that report? As a law enforcement officer, you will seize people and things, you will make arrests, and you'll do searches. These activities will be common experiences for you. In fact, most of the time, there won't be anything unusual or exceptional about any particular seizure, arrest, or search. In addition, afterwards, you'll be required to go back in the field and do more of the same. Eventually, one of your cases will be presented in court. Suppose instead of talking about seizing people, making arrests, and conducting searches, we were talking about eating lunch. Eating lunch is probably a common experience for you. If I asked you, what did you eat for lunch yesterday, you could probably tell me what you ate. You may be able to tell me the order in which you ate each item. Now, if I asked you, what did you eat for lunch 3 months from yesterday, you would not be nearly so quick to answer or nearly as sure of your answer as you was about yesterday. If I asked you about 6 months ago from yesterday, you probably would not have a clue what you had for lunch or if you ate lunch at all. What if it was important that you remembered? Suppose if you cannot remember, someone will be released from jail that will harm the person that you care about most. Think about that person. Now, can you remember? Could you swear to it under oath in a court of law? If you had written down the information soon after it occurred, that is, soon after you ate lunch, and you reviewed that information, could you be 100% sure of what your testimony would be about eating lunch? Yes. That's the importance of writing a good report. But what makes a good report? Facts and circumstances. Virtually every law enforcement officer I met as a prosecutor told me that he was taught to put as little facts in the report as possible so there would be less to be cross-examined on if his case went to trial. This is one of those examples of when good intentions causes bad results. It is true that unnecessary facts should not be put in your report. However, a good report should establish several things. One, when did the incident occur? Where did the incident occur? Those things deal with your jurisdiction. Who committed the crime? That is, facts which prove the identity of the suspect that committed the crime. And finally, 4, what acts the suspect did which violate the law. All facts that go to establishing your probable cause when there was an arrest or a search should be in that report. All facts establishing the right to conduct a Terry stop or to conduct a Terry frisk should be in your narrative report. When the facts involved the suspect's actions, it is critical that the facts be provided in a manner as if they were to be reenacted by actors for the reader of your report. That is, if the actors were told the information in the report, would the actors know what to do? For example, which is easier to reenact? The officer says the suspect turned toward me in an aggressive manner. Or the suspect bladed his body toward me, clenched his fist, and began taking deep breaths. The phrase that best tells the actors what to do also gives the reader the facts needed to best understand the circumstances dealt with by the officer during the incident. If the reader cannot reenact what happened, the officer is providing conclusions, not facts. The facts, not conclusions, should be provided in your report. Let the reader draw the same conclusions you drew from the facts you provide in your report. I have one final suggestion. It goes to organizing the writing of your narrative report. 4 W's and O. When, where, who, what, other. These are the questions I would ask victims and witnesses and officers before I presented their cases. When did this incident take place? This question addresses the issue of the statute of limitations. Most charges have to be prosecuted within a period of time referred to as the statute of limitations. There are events that will toll or stop that statute of limitations, but barring one of those events, if the charge is not prosecuted within the statute of limitations, the government loses its ability to prosecute the charge. Where did the incident take place? This question addresses the issue of jurisdiction. That is this the correct government agency which has the authority to prosecute the charge based upon where the crime occurred? Most agencies have some jurisdictional limitation on the areas where they can prosecute a crime. For example, the City of Atlanta Police can only prosecute crimes that occur within the City of Atlanta, city limits. If the crime occurred in the county that is unincorporated City of Atlanta, the City of Atlanta courts would not have jurisdiction to hear the case. Who? Who goes to how do we know the defendant did it? It is not enough to prove that a crime occurred. You must prove that this is the person that committed the crime. This is the one that the officers arrested. And there should be some facts, not conclusions. An example might be a witness said that the suspect was a white male with dark hair, about 6 feet tall, with a red T-shirt and light brown shorts. The officer could write in his report that he stopped the defendant who matched the description that was given on the be on the lookout for, or BOLO. By saying that, it is a conclusion that the defendant matched the description of the BOLO. It would be better to report what the officer observed that caused him to come to that conclusion that the defendant matched the BOLO. He could say, I observed a white male with dark brown hair, approximately 5'10", wearing a red Washington Redskin T-shirt with tan cargo pants type shorts. Given this description, the reader could come to the conclusion that that defendant matched the BOLO when the officer stopped him. Finally, what? What happened? This question addresses the conduct of the accused as well as establishes the elements of the charge. For example, in 18 U.S.C. 641, theft of government property, the elements of this charge are that a defendant voluntarily, intentionally, and knowingly stole property belonging to the United States with the intent to deprive the United States of the use or benefit of that property. There should be statements in the report which support each of these elements. Finally, if you've asked the 4 whats, there's one other question you should ask your witness or victim. Is there anything else about the case that you feel is important? While approximately 9 out of 10 times when I asked this question, the answer was no, on numerous occasions, very relevant background information was provided by the victims that I otherwise would not have known because I did not ask. Usually this information establishes the intent or motive, or sometimes it goes to the identity of the suspect. In conclusion, if in writing your reports you provide the when, the where, the who, the what, and you ask that other question, plus you provide facts, not conclusions, you will have written a report that provides the prosecutor and the defense attorney with all the information they need to make their decisions, and you will have provided yourself with a single source report that you can review when you need to testify in court. I thank you.